This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're talking, can my boss do that? We're interested to hear what's going on at your place of employment. What's your boss trying to do? So everything from, we're going to talk about discrimination. We'll talk about drug testing, work conditions. Have you been curious what your boss might do if they saw something on your social media that they didn't approve of? Not even anything necessarily controversial, just something they don't agree with and they don't like. Can they fire you for that? Call in your questions on anything. Can my boss do that? 256-536-0077. You can also email your questions. You can email any legal question any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we will pull some out. We've got some of your email questions tonight. Getting us started tonight, Will League is here from Timberlake and League.
All right, Sharon.
We always look forward to, can my boss do that kind of questions. Everybody's had jobs.
Exactly. We're all, we're all in there trying to make it happen on the hamster wheel. What does we talk about? Can my boss do that? What does that actually entail? So, can he make you? Can he or she make you come to work during an ice storm?
During an ice storm.
Family Medical Leave Act, American with Disabilities Act, sexual harassment. Sometimes the tech companies that they discover the best app or whatever widget, and you have a stockholder squeeze out, so they can kick people out, and is it legal to do within your particular corporate structure? And so we're taking all those questions tonight, anything regarding work-related or ICE-related, since that's kind of where we are. I understand we have a kind of a crazy video.
We've got a video tonight. So before we get to your questions about can my boss do that, we've got a video we've pulled from YouTube. All right, so here's the situation. You're trying to watch ahead of you, but something sneaks up behind you. It looks like one of these drivers saw it and got out of the way, but not so everybody else. So when you're looking at something like that, you guys do personal injury law. What's the rule with somebody hitting you from behind? Is it the person that hits you? Is it somebody that, if somebody crashes into you because they got shoved into you? Who's responsible?
Sharon, so this video, the guy must have been looking in his rearview mirror. He saw the 18-wheeler coming at a high rate of speed, was able to get over. And we sadly have these cases all the time. If someone hits you from the back, are they automatically at fault? Not automatically, but usually under the law, you got to do to maintain a proper lookout, maintain a safe distance between vehicles. Obviously, that's not going on right here. With a lot of these hard-hit rear enders, we're really seeing a lot of distracted drivers, and you hear it all the time. Once we, if we download the data from his cell phone, we'll probably find that there are several apps streaming at that particular time. Yeah. There could be, he could be doing email, Snapchat.
Texting.
There's just many different ways. And oftentimes we'll look at that particular data and determine exactly when the wreck happened, what the speed was. You look at the longitude, latitude, and all those things from the data from that particular phone.
Pretty accurate.
Was it upright? Are you holding your phone upright at the time?
You can tell that from the data?
If it's flat or if it's upright, if you're actually using it.
I didn't know that.
We're seeing a lot of those cases, and unfortunately, significant injuries when you talk about, high speed with a lot of velocity from the 18-wheelers. So in this particular case, it's clear 18-wheeler was coming in too fast. Those other cars were just going with the flow of traffic, and he wasn't paying attention. It's possible there was some type of mechanical failure.
Yeah, could be.
And sometimes that's a defense, but again, did they do a pre-Christmas inspection? Should they known about the brakes being faulty or anything like that? And those are things that if the litigation ensues, you'll be able to get discovery and get to the bottom of those things.
So tonight, taking your questions, can my boss do that? And you brought a great expert with you.
I'm so glad we have our good friend Terry Mastando with Mastando and R-Trip to answer a lot of these questions. It gets very technical when you talk about federal law, state law, how many employees you have to have, and all those things matter if you're going to invoke federal law. And one of the main ones, Terry, and thank you for coming up here, is Title VII of the 1964 Civil Rights Act. Now, you do a lot of discrimination, sexual discrimination, harassment, age, a lot of employment type work. How does the federal law, Title VII in the Civil Rights Act, come into play in a lot of your cases?
So that's a very important statute that I deal with every day at work. It covers various types of discrimination in the workplace, sex, race, national origin, veteran status, mainly. So basically, if you employ 20 or more employees, then you have to comply with Title VII, and you cannot discriminate against people for those reasons: sex, race, national origin, and that includes sexual harassment and pregnancy discrimination.
And now that's under federal law. So if you got less than 20 employees, still it's no free reign on that, but state law may come in and help you in that regard, or is it no holds barred when you got less than 20 employees?
You know, that's a great question. There is another federal law. When it comes to race discrimination, there's another federal law. It doesn't matter how many employees you have. So it's definitely a bad idea to discriminate for any of those reasons, even if you have less than 20 employees. So there are state laws that may come into play there.
Mm-hmm.
We've got callers waiting. Larry's on the line with a question from Huntsville. Hi, Larry. Thanks for calling. What's your question tonight?
Yes, hi. Thank you.
Sure.
Well, now it's a two-part question.
Okay, let's try.
The first question is this recent ice storm,
Okay.
my boss threatened to fire me if I didn't show up. So I showed up for work, and they closed the parkway in I-565 East.
Yes.
So can my boss still do that even though I requested to go home?
Good question. I bet there's a lot of people who've had trouble with
Right.
bosses this week.
And it's not a good answer for the employees. They're not bound by, a lot of times, well, schools are closed. Does that mean that we don't have to go? Absolutely, it does not actually. Your boss can. Well, can he force you to get in your car and drive? No, but he can not pay you if you don't come, and he can also let you go. So absent any type of employment agreement to the contrary, if the boss says, hey, you've got to be here and you're not there, A, he doesn't have to pay you, and B, there could be repercussions with your job. And it's kind of a tricky widget because Alabama is an at-will employee state, which means unless you have an employment contract, you can be hired or fired for any reason or no reason, with the exception of race, religion, national origin, and things that Terry just mentioned. So Terry, it's a tough law in Alabama, an at-will employee state for employees. But if they violate one of those provisions, what are your rights at that point?
So one of the things that came to my mind, listening to people talk about did they have to come to work, some people may actually have a disability or some actual physical medical reason that they can't drive on icy roads or they can't be out in the cold. So that is one thing to take into account. But generally, employment at will is going to mean that an employer can make those decisions, as far as requiring you to come in or deciding not to pay you. Based on their business needs. And if you decide not to come in or if you don't want to do it, then they can fire you. They cannot pay you. The only exception I could think of is perhaps that if there was some kind of disability or medical reason you needed to not be out on the road, and if there was some kind of accommodation you could request.
Now let's talk about the Americans with Disabilities Act. If you have some type of life-altering physical condition that affects you, then you could fall under that category. And what rights does that give you if you comply with the ADA? Your employer has 15 or more. Let's say your boss says you have to drive and you've got a physical disability that you cannot per the doctor's orders. Will that get you outside of the at-will employee if you're fired?
It absolutely could. The Americans with Disabilities Act has two very important functions. The first thing it does is says employers cannot discriminate against you simply because you're disabled. They can't say, oh, you're in a wheelchair, we're going to fire you. But the other very, very important part of it is it requires employers to give you a reasonable accommodation if it is medically necessary because you have a disability. So that becomes a process between you and the company back and forth to try to decide, is it reasonable what I need? Is it reasonable that I can't drive today because I can't drive on ice per doctor's orders? So it does mean you have some protection in the workplace.
Mm-hmm. We've got Tina on the line with a question from Florence. Hi, Tina. Thanks for calling. What's your question tonight?
My question is, I recently lost my job at the end of August, and the reason for me losing my job was that my supervisor had told some things that I was guilty of, which I was not guilty of. One of those things that he had said was that I was disrupting production and a few other things. Plus, he proceeded to, in other words, slander me in front of the whole plant. Okay. I have recently been without an income for this long, and now I am being evicted from the apartment I live in because I could not find another job.
Yep.
And I just want to know, can they do that?
Terry, lead us down a path. What can we do about something like that?
Well, that sounds like a tough situation. And unfortunately, the general rule, like we spoke about before, is employment at will. So an employer can be unfair. They can let you go for a bad reason, an unfair reason. The flip side of that is you could quit for any reason with no notice and walk off of a job. But the problem is situations like yours where you're treated very unfairly. So what I tell people when they call is think about your situation. And is it unfair because of a federal law? So you have to look at the federal laws. The protections are age, race, sex, national origin, veteran status, disability. Those are the main categories. So if you look at your situation, if you think your termination had to do with any of those things, like for example, your supervisor did not treat a man who did the same thing you did, in the same way, and fired you but chose not to fire the man, well, that looks like sex discrimination. So you have to look at your employment situation that way in light of what kind of protected categories. If it's simple unfairness, I'm afraid there's not legal protection for that.
Not against the employer. Let me ask you this. So let's say supervisor made up something maliciously to get you fired. I think you mentioned disrupting this or whatever. Let's say that it was totally uncalled for, it was totally inaccurate, and it slandered you. Now, slander per se is if someone, does anything to diminish your character or something that causes you harm by the spoken, or I think libel is a written word, but slander the spoken word. And let's say you are fired. Theoretically, you could maintain an action against your supervisor for slander unless there's some type of co-employee exception that we have to look at. But let's say he made it up, you're fired because of it, you may have a claim against that supervisor that made up the outlandish statements. Yeah. But again, you have to prove it to a judge or jury, depending on what court you're in, to determine whether or not that's a reasonable assessment that it was, in fact, the supervisor's words that caused you to get fired. We're charting new ground. Never seen that case go before, but theoretically, Terry, that's something you could maintain a claim for. Now, how do you determine damages? So let's say Tina, in this case, hadn't had a job for 3 months. Let's say it's $5,000 worth of damages. Would it be that in attorney's fees? And how does that differ from Title VII on a Civil Rights Act claim? Are attorney's fees built in, or how do people pay for an attorney like that?
So if you're asking about the slander part of it, like if you sue some individual for slander, it's just a common law tort. Right. So, there's no attorney's fees. It's just basically what are your damages? What are the lies they told about you? What does it cost you? And a good measure of that is pay. In the civil rights world, it's pay plus compensatory or mental anguish damages plus punitive damages. All those three things you can recover, and attorney's fees on top of that if you win in court.
And punitive damages could really be substantial. I mean,
they can be. They're capped under the federal employment laws. They're capped at a maximum amount of $300,000 for employers of over 500 people.
Okay. So. They're telling us take a break. We'll take a break. We'll come back and we'll talk about how do you prove your case? How do you prove that your boss fired you because you're female or whatever the circumstance was? How do you prove that? Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're talking about Can My Boss Do That? We've got with us Will League from Timberlake and League and Terry Mostondo from Mostondo and Artrup. She does those kind of cases all day, every day, so it's fun to hear what everybody's going through and what you can do about it. Everybody's had a lot of ice and snow. We had those ice and snow questions already. You had some ice and snow.
Right. Well, we're up on beautiful Montesano Mountain, and it's some of the best sledding. There's Ashley and my daughter Harley sledding down beautiful Montesano Mountain just a few days ago.
Y'all had a good time.
It's great. It's beautiful up here, and glad everything is melting, and so everybody get back to work. But it was a great time while it lasted.
Terry, you've still got some ice where you live, right? Being super careful?
My driveway's still iced over, and I used to love to sled in Chicago when I was a girl, but I've experienced it already.
Glad everybody made it through, for the most part,
Yeah,
safe.
and we've had a lot of calls. We've seen neurosurgeon Rhett Murray talk on the news about all the injuries and
Yes.
people sledding into cars and kayaks and all those sort of things. And usually, contributory negligence in Alabama, if you cause or contribute to your injury even slightly, there's no recovery to be made. If you take your car on a closed road, will insurance pay for your vehicle? So laws, things change when the roads are closed and you're engaging in reckless conduct. And I get it, we all like to sled.
We do.
But there's not a lot of recourse if something goes bad.
Okay. Talking about can my boss do that? Talk a little bit about social media. What can your boss fire you for something that you post on your social media? And how bad does it have to be for them to be able to get away with that?
Well, honestly, the general answer to that question is yes. I mean, you really have to be careful about what you put on social media. Now, it's more clear, obviously, if you put something on social media that's harmful to your employer in some way.
Okay.
That's something that employers can look for. But freedom of speech, things like that, don't apply in the private world of employment.
So, like, if you put something against a political candidate, and your boss likes that political candidate, they can fire you for that?
They can. They can. Again, free speech is from government can't impede on your free speech rights.
Okay.
But your employer, they don't like it, they can. Unless there's, again, a contract to the contrary, which I couldn't imagine there would be. But unfortunately, there's not a lot of, not a lot of recourse there.
How about drug testing? Can your boss drug test you? Can they force you to take a drug test?
They can.
They can. As long as they don't do it in a discriminatory manner.
Okay.
For example, if they are drug testing just one sex or the other, or that sort of thing. But generally speaking, it also gives them workers' comp protection too if they do drug testing.
Okay.
And we talked about if you test positive for a legal substance. Legal substance. Now, if they can somehow determine that it was on the job, then they could let you go for that.
You thinking like alcohol?
Alcohol. Let's say they test you at noon and it shows that you're 0.9, you're 1.9.
Okay.
That's in your blood, so you've been drinking on the job. They could fire you for that. And again, when you go back to the any reason or no reason, it's just so inclusive. It makes it difficult.
We got this email question. This was written in by Carrie. Carrie says, I've been operating a business out of my home for 2 years, and I'm finally ready to hire a full-time employee. I know this makes running my business much more complicated. Any advice you can give me for what to do or not do as I start down this path? Well, that's great. She's growing her business. That's good. And she's still small, so maybe she gets away with some things that she wouldn't otherwise, right?
Anytime you're first starting a business, you want to find out what type of vehicle you want to be. Is it a sole proprietorship, which is one person? Is it a partnership, you and another person? Is it a limited liability company? Is it a corporation? And all your flow through tax, if you're a sole proprietor or if you're a corporation, will you be taxed separately? What type of business are you in? What do you need that extra protection? Do you need investors? Can you get limited partners that don't really run the company but help you with some type of financing or capital for that company? So you want to find out exactly what type of vehicle to limit your liability, and you want to make sure you've got the right insurance. She's talking about hiring an employee. Do you advise people to have an employment contract if you're representing the employer?
Employment
because
contracts.
What this lady would be.
It can be, as long as it's the right kind of some people need employment contracts to protect the confidentiality of the information, because when you hire an employee into your business, you have to share business secrets with them, you have to share confidential information with them, so you want to make sure if there's any kind of contract, not necessarily a contract for employment for a certain amount of time or anything like that, but maybe some things in place to protect your confidential information that they have access to. When you get up closer to the 15 employees, you really need to consider an employee handbook. To make sure that you have all of your policies set out in one place where employees can find them.
Right. And if you have 5 or more, you'd have to get workers' compensation insurance, make sure you're covered if something bad happens. And up to that, it's the Employers Liability Act, and you could be liable. So again, make sure you have general liability insurance. And so sit down with the business attorney, make sure you've got your ducks in a row and I's dotted and T's crossed.
Okay, we got this email question in from Quan. Quan wrote, shouldn't I be getting paid for training that my job requires me to have? Should you get paid for that, or can your employer force you to go to that training and not pay you to do the training?
So actually, yes, generally speaking, you do need to be paid if your employer is requiring you to do the training. Now, there are some situations if the employer tells you in advance, the law that you're looking at is the Fair Labor Standards Act. So that law basically says you have to be paid at least minimum wage. So they may only have to pay you minimum wage, which is currently $7.25 an hour, and they can pay you some less than normal as long as they let you know in advance. And there are some, squishy parts of it too about, is it training that benefits just the company, or is it something that benefits you as well? But if they are requiring it, generally, yes, they need to pay you.
Sometimes where it gets messy is, okay, let's say you go to training, can they take that off your hours and not have make time and a half later on in the week? And so you want to look and see if that you get those hours for your training. Hopefully you can do it during the work week, but sometimes they're sending you off, and what does that do to time and a half if you're an hour employee?
We got a shy caller that had a question about unions. So we don't have a whole lot of unions down here, but it does seem to protect employees more. Are you seeing that what union employees there are? Have you had any experience with that to know whether that really protects somebody, or Alabama laws are just pretty wide open?
I do have some experience with that. There are very few unions up in North Alabama. The ones they do have, they do work for their employees, and it kind of takes you a little bit out of the employment at will that Will and I have been talking about, because that is a contract. A union has a contract with your company, and your employment is governed by that contract. So it is a way around employment at will. So if in the bigger industries have those, and you're looking at the Starbucks or the the auto plants, but here again, very few auto plants up in this area have those.
Talk a little bit about non-competes. Can employers make you sign, and can they hold you to a non-compete contract?
The things on non-competes is they have to be reasonable.
Okay.
So if you've got a trade secret, or you can't just say, it doesn't apply to professionals, lawyers, doctors, things like that. But let's say we start a lemonade stand, and me and Sharon and Terry were doing it, and Sharon says, look, you can't open another lemonade stand within two blocks and for 2 years. That's probably reasonable,
okay,
under those circumstances, but it has to be reasonable as to geographical time and scope. And so based on...
If I say 20 years and for three state radius.
Right, I don't think that the court would enforce that,
okay,
and so it has to be reasonable, and that's what it comes down to. Is it reasonable on the terms of the particular non-compete?
Okay. They're telling us to take a break. We're going to take a break. Be right back answering your questions about, can my boss do that? If you didn't get your questions answered tonight, here's how to get in touch with Terry Mastando with Mastando and Artrup in Huntsville, 256-532-2222. Also check out MastandoArtrup.com. Here's how to get in touch with Will League with Timberlake and League in Huntsville. They are personal injury attorneys, so everything from auto accidents to medical malpractice. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And our very own Sharon Doviet, family law attorney, 539-7337, SharonFamilyLaw.com, child custody divorce. And if you've got a claim, you file with the EEOC within 180 days. Internal statute, right, Terry?
It is. It's a government agency in Birmingham.
And they give you permission to move forward or not?
Right. They get 6 months to investigate it.
Okay.
Thanks for all your questions tonight. Stay safe.